Thank you all. And I know we have a number of appellees, and I wanted just to make sure, I would imagine that you all have discussed among yourselves, and you're going to keep track of your time, or if you want me to keep track of your time as to who wants to get what, or just I want to be able to give you that before we begin with the argument.
Your Honor, we did discuss this beforehand. We kind of came to an agreement, which is all the appellees are going to split their time roughly equally 5 minutes apiece, depending on how counsel's initial argument goes. But we'll alert the court to that when we begin our argument.
Very good. And you're keeping track of your own time, correct? Or do you want me to? All right. Very good. All right. And with that in mind, the court is ready to proceed.
Your Honor, do we argue one appellee at a time, or the whole thing?
No, what you're going to do right now, you're going to be making your whole entire argument, and then you could save, if you want to save 5 minutes for rebuttal. That will give each of them an opportunity. You'll take 5 minutes. Each of them will take 5 minutes. Then when you come in for rebuttal, you'll be addressing all. Okay? So would you like to reserve 5 minutes?
5 minutes, Your Honor.
Excellent. All right. You may proceed, sir.
May it please the court, my name is Larry Florentin. I represent Appellant Barra Sebring in this proceeding. As to Appellee Better Roads, we respectfully request the court to reverse the final judgment in favor of Better Roads. Two issues regarding the final judgment that is important is that the final judgment was based on unpled theory. Better Roads filed a claim of lien for about $54,000, of which $13,000 remain unpaid. The trial court found that Better Roads was not entitled to a lien against Braha's property because at trial, Braha provided proof that Better Roads was paid in full based on the claim of lien. But even though the court found Better Roads was not entitled to a claim of lien, he entered judgment for Better Roads. The Better Roads argues that the claim was based on a check that was returned based on insufficient funds, a worthless check. However, there was no mention of worthless check at the recorded claim of lien, or during the motion to dismiss, or at the motion for summary judgment, or even in the affidavit.
Was Mr. Restino deposed? Did you take his deposition?
No, Your Honor.
Okay, because when Mr. Restino testified, he testified that the total work was $82,000. And then he testified that Better Roads had paid $69,000, leaving a balance of $13,000. They introduced the NSF check into evidence, and you did not object.
Your Honor, I don't believe that they introduced the insufficient check into evidence.
The check is in evidence. It is an
check.
Exhibit. I can show you. It's right here. I've got it in my packet. So, no, I'm still asking you a question. They admit a copy of the NSF check for $17,800. You don't object. You don't object when Mr. Restino says we did total work for $82,000. You don't object when Mr. Restino says they paid us $69,000. Already, he's testified to numbers inconsistent with the claim of lien. That is a moment of surprise, if indeed you're prejudiced. There's no objections at all. The bottom line was Mr. Restino said, you owe me $13,000. So when Better Roads rests their case in a non-jury trial, you have the opportunity to move for an involuntary dismissal. You did not do that.
But Your Honor, there was no need to move for an involuntary dismissal because the trial judge already found that there was no claim based on the claim of the lien.
No, what I'm saying is during the trial, when Better Roads rested, when Mr. Restino was finished, that was your opportunity, according to the rule, to move for an involuntary dismissal based on the sufficiency of the evidence. You didn't make that motion. And case law says if you don't make that motion, any challenges to the sufficiency of the evidence is waived. So you go into your defense case, and Mr. Cortez immediately admits that the contract was for $539,000, and that contract is introduced into evidence, and it shows Mr. Cortez's signature, which says this is a binding contract. And then he testifies as to the check. He says we paid $54,000, of which that $17,000 bad check was part of it. Oh, by the way, we issued another check and made it good. There's no argument or discussion to this trial judge. Judge, this is a surprise. We are prejudiced from this testimony. We've never heard this before in our lives. It's never been in discovery. We move to strike. We move for a dismissal. We do something. There was nothing. So then, as you tried to ask B.R. Rhodes' witness a question, or you're asking Mr. Cortez why he told B.R. Rhodes not to finish the job, the B.R. Rhodes attorney objects and says this is irrelevant, etc., etc. And here's what's telling from the judge. The judge says, I heard testimony from B.R. Rhodes about the insufficient check, and that's the reason they quit. So I'll let you go ahead and tell us why you think that. So he allowed you to ask Mr. Cortez why he told them to go off the job. So at that moment, then and there, is the judge's recognition, okay, I've allowed this check in, but you still did not argue to the court. We're surprised, we're prejudiced, I moved to dismiss, it's improper discovery, we were not aware of it or anything. So my question is, after that recitation, is how is this preserved, sir?
Okay, Your Honor, the issue is preserved. It's because there was no other basis for the trial court to enter judgment. And I'll tell you why. If the claim of lien is defeated, then you have to have another basis, whether it is a breach of contract claim or unjust enrichment claim or some other count. There was no other basis. Because
but Mr. Ricus, one of the things to follow up, you can always have a trial by consent. You could always, we've had cases where maybe nothing was pled, then they go through, things come up, and then there's sometimes the attorneys would consent. And I think to follow up with Judge Sleet's questioning, if it was truly a shock and a surprise, you needed to preserve that because our hands would be tied. We cannot go through that.
Yeah, it is true, Your Honor. However, there was no trial by consent because some of the cases, cited, there was stipulation, or that issue was raised during motion to dismiss, or the issue was raised during motion for summary judgment, or there was the issue during opening statement or closing statement. But in this case, the only testimony was at trial. The fact that, the plaintiff has the burden to prove his case, so Braha has to wait and see what happened, what they have to prove, because...
Yeah, but that's why you're allowed to object, sir. Once you heard testimony of the $82,000, because part of your brief indicates that you were not aware that they were claiming that the total work was $82,000. Once he testified to that, you would expect an objection. There was not one. Then when he testified that Braha had paid him $69,000, you would expect an objection to that because all of your arguments were that you paid $54,000. You've already heard two numbers that, according to your brief, you've never heard before. So, and what I don't understand is Braha then introduced a document that shows that Braha indeed paid Better Roads $69,000, which contradicts Braha's testimony that we paid the $54,000. Actually, you paid $69,000. So all of the exhibits conform to the testimony of Mr. Restino. So explain to me how that evidence adduced at trial doesn't conform. How can you not consider that to be an amendment to the cause of action, or it's being tried by consent?
Okay, Your Honor, with respect to the $69,000, it was only testimony. It's not like, they provide evidence, like, check, we paid them $69,000.
Well, but I have to stop you there because this is your exhibit, Braha's exhibit. It shows that you paid Better Road $69,626.38.
This is something we prepared. It's not a check, we pay them.
No,
so
it's introduced into evidence, sir, so that means that the court has admitted it as a truthful exhibit. So,
yeah, I understand that, Your Honor, but if they raised the issue for the first time at trial, and then Braha challenged that, because we did ask questions. For example, Mr. Saber asked the witness, well, why did you file a claim for $54,000? And then now you're talking about $82,000. He claimed that there was a mathematical error in the claim of lien.
At that moment, there should have been a motion for mistrial. At that moment, should have been a motion for mistrial, a motion to dismiss, a motion for involuntary dismissal, because it wasn't pled. But there was nothing done, so I'm not sure what we're reviewing here.
And then in addition to that, they said, well, did you amend your complaint? And they said, no, they didn't amend the complaint because, hey, they had opportunities throughout the proceedings to amend the complaint. If they were making a claim for $82,000, they have plenty of opportunity to do that. But it seems to us that at trial, they can't simply just say, okay, testimony, well, they owe them $82,000, while the statute said they have to file a claim of lien. And the claim of lien they filed, this is the operative documents that Braha relied to prepare a defense.
But did you point out the error to the trial judge, sir? Did you point out this error to the trial judge when it occurred?
Your Honor, Mr. Saber only asked questions regarding the surrounding testimony regarding that.
Did Mr. Saber point this error out to the trial judge and give him or her an opportunity to rectify it then?
Well, it appears that there was testimony on the part of Braha, countering what was paid and what was not paid. So basically, I understand that a proper objection would be a timely objection would be the most appropriate things to do. But at the end of the day, let's assume that they didn't object, but Betterwood has to provide a basis for its claim. And then the operative documents is the claim of lien. So it cannot, on the same day of trial, saying, okay, hey, they owe me $82,000. And the law says you have to provide the defendant a fair notice, an opportunity to prepare a defense, to gather evidence and witness in opposition to the claim. That was not done in this case.
All right, I apologize. We've used up 11 minutes. You have other claims. Go ahead, sir. You have other issues.
Yes, Your Honor. Now, as to Florida, ATI, and Hickey, the issue is whether Braha should be held liable twice for the same wrong. The Florida ATI did not have any contract with Braha. Hickey did not have any contract with Florida ATI either. But Florida ATI is a subcontractor that filed its own claim of lien, perfected the claim of lien, filed its own independent action. So there was no basis for Hickey to include in its complaint the amount owed to Florida ATI. The trial judge was aware of that because it entered a judgment one for Florida ATI and one for Hickey. What we are contesting is that the judgment for Hickey should have been reduced by any amount included in the judgment for Florida ATI.
Let me ask you a question about that, because Hickey put on their case, and when Hickey proved their damages, the amount of the damages included ATI's lien. And when it came time for defense, and I'll credit Mr. Cortez, I guess that's how you pronounce it, Mr. Cortez said, well, I really don't defend against that because he's an honest man and he's now shown me all of his invoices And there was no defense at all mounted against Hickey's claim, if you read the transcript.
That's correct, Your Honor.
And then ATI then puts forth their evidence, and there is a defense against that. So as it relates to the Hickey judgment, there was no defense against their evidence. You conceded it. But more importantly, did you file a motion, or did Mr. Saber file a motion for rehearing once these final judgments were entered?
No, Your Honor, we didn't file a motion for rehearing, but the basis for our argument is based on the statute. The statute says that you cannot hold an owner liable twice for the same wrong. So,
I understand that, but the law also says that when an issue arises for the first time in a final order, or if the error is one that first appears on the final order, an objection must be preserved by filing a motion for rehearing.
yeah, but Your Honor, as far as the judgment for Hickey and Florida ATI, this is fundamental error, because it's not like we're saying, well, we should not pay any of them. We're just saying we can only be held liable for just one claim.
I mean, this is a civil case. And the proposition of law that I'm citing to you is a civil case. This isn't a criminal case. This is a civil case, and it says if the error appears on its face, you've got to file an objection, preserve it by a motion for rehearing. So fundamental error would imply to me that there's error on the face of the judgment. Is that what you're arguing?
Well, it is not an error. It's probably the way the trial court constructed the final judgment. Because at the end of the day, if Hickey is entitled to the judgment, Hickey just needs to pay Florida ATI. If Braha is required to pay Florida ATI, we are asking that, hey, the judgment for Hickey be reduced by any amount owed to Florida ATI. Because at the end of the day, Florida ATI is a subcontractor that is entitled to an amount by Hickey. Well, in this case, they're taking the position that, hey, Braha has to satisfy both judgment. But the law, the statute says that only one claim. The fact that, Florida ATI provided notice, so Braha could not have just paid the final payment to Hickey without satisfying the claim of Florida ATI.
Yeah, but Hickey didn't file a lien claim. Hickey filed a breach of contract claim.
Yes, that's correct, Your Honor.
So how does the statute apply?
The statute applies because Florida ATI is a subcontractor, and Florida ATI filed its own reported claim of lien. So basically, the statute applies to the case in terms of giving notice to owner.
And Mr. Flirton, you're actually going into your rebuttal time. Would you like to proceed, or would you like to save that time in response to the others?
Yeah, and I would like to at least take 2 minutes to address the claim of Tripoli.
All right.
As far as Tripoli, Your Honor, we request the court to reverse the final judgment because there was a defect in terms of recordation of the lien. Tripoli was required to record one lien for each separate contract. It is undisputed that there are 6 separate contracts in this case, and they reported just one claim of lien. They argued that they were relying on the contract between PCC, the general contractor, and Braha to record just one claim of lien. That should not be the case because Tripoli was not a contractor. In order to be a contractor under the statute, you have to have a valid contract with the owner, or you take over the entire remaining contract by the contractor. In this case, that was not done. So basically, in this case, Tripoli failed to record a claim of lien for each of the contract. Now, as far as damages, PCC is the one that hired, or at least that had a contract with Tripoli. They filed a complaint stating that they only owed Tripoli $58,000. It is undisputed that Braha paid Tripoli $15,000 after the claim of lien was recorded. So we saying that, hey, the trial court entered excessive judgment against Waha because the claim of lien should be $50,000 based on the statement of account by PCC. Once you subtract the $15,000, that would be any amount owed to AAA. I'll reserve the rest of my time.
Thank you, sir. All right. Who would like to proceed first?
AAA, Your Honor.
All right, sir.
Good afternoon. Mark Schaubacher on behalf of AAA. I tried this case, so I have a passing familiarity with what was, and more importantly, was not done at trial. Point out at the outset that the trial judge's decision comes in with a presumption of correctness, and it's due to be affirmed if there is competent and substantial evidence in support of his judgment. We like to point out at the outset that every bit of evidence which supported Judge Langford's ruling in favor of my client came into this trial either by stipulation, stipulated facts, stipulated documents, etc., or by testimony at trial to which there was no objection. The issues that are raised here before this court, at least two of them, were never raised at the trial court. Those relate to the issue of service of a notice to owner or the multiple lien, multiple contracts, singular lien. They were not at all broached to Judge Langford, either in opening at any time during the trial or in closing. There was no motion for involuntary dismissal. There was no motion for rehearing. We sit here today wondering how and why there could be an appeal in this case under those circumstances. The only issue raised here on appeal, which there might be a scintilla of objection at trial, relates to the amount of the damages. Braha Sebring's position throughout this trial was clear, restated by Mr. Kertész in his testimony, restated by their counsel at trial. When it comes to AAA and what is due AAA on this job for the rental equipment they provided, we don't have a problem paying them what they're entitled to. We just can't figure it out. Well, Judge Langford had no problem figuring it out on uncontested evidence that came in at the trial. The suggestion that a single claim of lien should have been recorded in this case is incorrect. The case points out the problems that most people have with the construction lien law that the appellate court has recognized as one of the most confusing statutes here in Florida. It is a definition-driven statute. Under the statute, you have to look at who is a contractor, who is a subcontractor, materialman, and so forth. It's all definitionally driven. And in this case, if they're only going to talk about the single claim of lien, first of all, there is no statutory requirement that anyone record a single claim of lien for each and every contract they have for improving the property. The only thing that comes close to it is a Florida statute 713.09 that says a lienor may record a singular claim of lien for all of its work on the project so long as it is under the same direct contract. The direct contract is defined in the statute as the contract between the owner and another party.
And it's your argument that this statute contemplates materials furnished, because we don't really have work here. We've got AAA is renting heavy equipment.
Yes, sir.
And all for subdivision improvements.
Correct, sir.
All right.
And by definition in the statute, furnishing materials expressly includes furnishing rental equipment. There's no doubt about that. But in any event, under 713.09, so long as the direct contract between the owner and the contractor is the same, subcontractors and material suppliers underneath that contractor can file a single claim of lien for all of their work, whether it's done on 1, 2, or 3 subcontracts, or purchase orders. And we gave an example in our brief as to how that works in the real world. In my case, in this case, my client was a material supplier to a contractor. The direct contract was always the same. 713.09 allows me to record a single claim of lien even if there were 6 or 600 separate rental contracts for the pieces of equipment. Moreover, if you look at the testimony at trial, my client testified that the contract here really was to furnish the equipment to the job for these subdivision improvements, and that the documents that were captioned a contract merely identified the piece, the rental rate, and so forth. So technically we have one contract, but even if we didn't, under 713.09, we're only required to record one claim of lien. Their next argument deals with the sufficiency of the damages. As the record reflects, my client testified as to the amount that was unpaid. All of the paid invoices were admitted without objection. All of the unpaid invoices were admitted without objection. The table reflecting the accrued prejudgment interest was entered without objection. He testified as to the amount that was due from the perspective of Appellee. Beyond that, we had the testimony of Mr. Harvey Mart, the president of the contractor, who in deposition, which was admitted in evidence at trial, testified that he agreed completely with Appellee's position as to the contracts, when the equipment was furnished to the job, when it was last furnished to the job, that where it was there throughout the entirety of the job. He agreed that they were owed the amount claimed in the claim of lien, which was at that point in time was recorded $79,000, and that it was unpaid.
Do we get to the sufficiency of the evidence if there was not a motion for involuntary dismissal?
No, Your Honor, and there was nothing to put the trial judge on notice that there was any question of this. They said at the outset, we acknowledge we need to pay him what we pay him. We just can't figure it out. But as I said, Judge Frankfurt figured it out real quick. They didn't figure it out. My client was never deposed at any point in time. There was no cross-examination, in essence, of my client as to the amount. There was, questions about different contracts and so forth, but nothing really challenging my client's assertion that, as we are here today at trial, it's $62,000 in unpaid invoices. Period. Full stop.
Well, it seems that Mr. Cortez testified that PCC rented the heavy equipment without my knowledge.
No, sir.
That's what I have as a quote.
Well, he may have said that, but I guarantee you there's other places in that transcript where he acknowledges that Appellee was out there. That was never a question that the Appellee invoices or rental equipment was unknown to Mr. Cortez. As a matter of fact, there is testimony, I don't want to say it's in this record, but Mr. Cortez was aware that my client was out there and submitting invoices, and his testimony at trial was that he would review those invoices as they came in from PCC. I do remember that, Your Honor.
Wasn't everybody behind the 8 ball because PCC shredded their records?
I wasn't behind the 8 ball, Your Honor. I had my records and I had PCC's president testifying. The shredding of the records, if I remember correctly, came several years after this lawsuit was filed, and long after discovery could have been had.
Mr. Shum, I know you guys are dividing your time, but you've gone through 8 minutes already, so I just want to alert you to that. Okay.
Good afternoon, Your Honors. Alex Brockmeyer on behalf of the Appellees, Florida ATI and Better Roads. We would just request affirmance of the judgments in favor of Florida ATI and Better Roads, and we will rest on the arguments as raised in our briefing.
Okay.
Thank you.
Good. Thank you, sir. All right.
Good afternoon. Kevin DeEspies for Hickey Excavation, excuse me. We would also ask the court to affirm the trial court's ruling. As Honorable Sleet has pointed out, this was a direct contract case between Hickey Contracting and Hickey Excavation, Braha Sebring. as pointed out by Mr. Kurse in his statement that he acknowledged that he owed Hickey the money. They provided no defense as to the amount. They provided no defenses at all in the trial. When the judge asked counsel for the defendant, do you have any defenses as to Hickey? He said no. Mr. Kurse, in his direct testimony, when I questioned him, said, I owe Mr. Hickey what it is I owe him. All the evidence was provided, evidence of all the direct amount, the full amount was provided, and unfortunately, there is a double recovery. As pointed out in my brief, in the Mechanics Lien Statute 713-062C, there's a warning that's placed on the notice to owner, and that says, warning, Florida construction lien law allows some unpaid contractors, subcontractors, and material suppliers to file liens against your property, even if you've made payment in full. Under Florida law, your failure to make sure that we are paid may result in a lien against your property and you're paying twice. They were clearly on notice that they were subjected to being having two separate judgments entered against them for the same amount. Again, since they did not present any evidence or any counter evidence in opposition to our claim, they cannot now come before you as a panel and say, the judge made a mistake. The judge had no obligation to inform them of their errors. Therefore, you have nothing more to do than, again, affirm the judgment.
It may have been you, but it was one of the defense counsels during their closing specifically said, Judge, this could be a situation where the defendants or Braha could face paying twice.
I said that, yes, sir.
Okay. And I note that there was no objection, no response, no argument.
No, sir.
All right, thank you.
Thank you.
Thank you, Mr. Nesbitt. Okay, and who's ready to proceed next? Anyone else?
Yeah, I believe are all done, Your Honor.
Okay, very good. All right, then you may proceed, sir, in your rebuttal.
As far as Hickey, Your Honor, the statute specifically stated that a subcontractor has to provide notice to the owner in order to make sure that the subcontractor is paid before a final payment made to the contractor. So, in other words, if Braha paid Hickey the full amount without reserving any money or paying Florida ITI, then Braha would be responsible to pay Florida ITI because Braha is on notice that Florida ITI has a claim. So, but the law says that the statute says that an owner or a contractor should not be held liable twice, should not be required to pay twice. And as I stated before, the issue is not whether Florida, even if there is an issue as far as the amount, but the issue is not whether we have to pay Florida ITI or whether the amount owed to Hickey, we don't have to pay Hickey. We're saying if we pay Hickey, then Hickey is responsible to pay Florida ITI. If the judgment for Florida ITI, if we have to satisfy that, then the judgment for for Hickey should be reduced by the appropriate amount awarded to Florida ITI. Now, as far as Tripoli, there is no question. The record has evidence that Braha raised the issue, challenged the failure to file a separate claim of lien for each distinct contract. The issue was raised in the motion to dismiss, in the affirmative defenses, and at trial. So there is no question that this issue was preserved. Now, as far as whether Tripoli is required to file a separate claim of lien, is supported by the decision of the third DCA, Lee versus All Florida Construction Company. So there is no question about that as far as whether Tripoli has to file a separate lien for each distinct contract. Basically, Tripoli is asking the court to allow it to rely on a contract between PCC and Braha, but Tripoli was not a party to that contract. And we're not asking the court say, well, hey, the question is whether Tripoli is a contractor. But Tripoli is not a contractor. Tripoli is a subcontractor. In order to be considered a contractor under the statute, you have to have a direct contract with the owner, or you have to take over the entire remaining work of a contractor. In this case, that contractor would have been PCC, but it is undisputed that Tripoli never took over the entire work because Tripoli was only supplying rental equipment, and PCC was overseeing the whole contract that has different components. So basically, there is the case law support opposition, and respectfully request the court to reverse the decision for Tripoli. Any questions?
Any questions? No,
No,
that's
sir.
all. Thank you all.
Thank you.
Thank you very much. And at this time, the court will stand in recess.